Welcome to Docket Decoder. If you enjoy our content, please help us out by hitting that like button or leaving your comments for us. And don't forget to subscribe to stay up to date with the latest court filings.
All right, now I think we're on the make and model of the suspect vehicle. Enjoy your seatbelt.
Your Honor, this is a motion where the words do matter. We're following up on that one. This seems appropriate. This motion, we're talking about the phrase used by the state, suspect vehicle number 1. First, this motion is grounded in Mr. Kohberger's rights to due process and a fair trial. Thinking of why we have this motion, we have to remember this is a highly circumstantial case. That's what this case is about. And one of the pieces of circumstantial evidence that the state will use is a video from a house on King Road, 1112 King Road. And that video depicts a vehicle. There are several views of that video with vehicles in it. The state will also use other videos that depict vehicles or a vehicle in surrounding areas. As they said in their response briefing, they do not have one continuous video loop. So the state's piecing together several videos and calling them all suspect vehicle number 1. That invades the province of the jury to make that determination. The state has Special Agent Imel, who will testify and identify a make and model of a vehicle from one of the many clips of videos that the state will use. That make and model cannot be identified from other than one view of that. This motion is not asking the court to prohibit the state from producing the videos or producing Agent Imel insofar as his testimony matches his expert disclosure. But this is about preventing the state from saying, this is suspect vehicle number 1. This is the same vehicle in all of these video clips. That's something that the jury will have to decide after they hear evidence to make that determination. This motion is important because that has been referred to, suspect vehicle number 1 has been referred to by the state in their affidavits for search warrants and other pleadings that they've written where the state has made this connection and they can't do that. This is up to the jury to make the connection if this vehicle in 1112 King is the same one that was in 1125 Ridge Road and other various places that the state intends to show. We're asking the court for an order prohibiting the state from making the reference of this as suspect vehicle 1 to state that as a fact, not to prevent them from presenting evidence in the way of video clips or expert testimony, but just to prevent them from invading the jury box when that's up to the jury to decide if that's the same vehicle, if it's a Hyundai Elantra, and if it's consistent with one that Mr. Kohberger drove at some point.
Your Honor, it is our expert opinion, who is a vehicle identification specialist, Anthony Imel. It is his opinion that the suspect vehicle, captured on various surveillance video, shares similar class characteristics to a 2014 to 2015 Hyundai Elantra. He specifically relied on certain video. While some are better views than others, but he relied on all video from 451 Paradise, 1125 Ridge Road, 1112 King Road, and all the WSU surveillance to come up to his opinion. His opinion is based on logical inferences of review of the surveillance footage, including observed traffic flow, the time of night, the direction of travel, and the camera timestamps. The jury should be allowed to hear his opinion, weigh that information, with other testimony and other admitted evidence and decide if they believe that that vehicle is a 2014, 2015 white Hyundai Elantra. Of course, the defense will have the opportunity to cross-examine S.A. Imel. That's the process, and that's the process that should happen. There are no legal grounds to exclude this opinion or to limit it. Thank you.
Our request is not at this stage to limit Agent Imel's opinion that's consistent with the timely disclosed report. It's our request to have an order from the court preventing the state from referring to the vehicle as one vehicle in all of these clips. Agent Imel can talk about the clips, we can view the clips with the jury, and he'll be subject to cross-examination. The motion is wholly about.
We'll say that this is the same vehicle on each of the clips, that
No.
his expertise.
No, I think he'll testify that it could be consistent. I think he'll testify he could only identify a Hyundai Elantra from the 1125 Ridge Road video. And I think that he will agree that his original opinion was that it was a 2011 to 2013 Hyundai Elantra. And I think he'll testify that only after Mr. Kohberger was identified.
It's not actually true. As I understand it, it was expanded before the 19th.
Let me back up. The email that I think was disclosed in the Franks motion to the court was that he preferred a 2011 to 2013 Hyundai Elantra, but open up the search through 2016. Moscow Police Department set out their Be on the Lookout flyer for a 2011 to 13 Elantra, and that's what was sought for a long time. Agent Imel in that email did say expand that year. The change that there's a vehicle, a Hyundai Elantra, that's a 2014 to 2016 came later, and that came after Mr. Kohberger was identified on December 19th, and in looking at WSU footage of a different vehicle. That's putting a vehicle together much later after Mr. Kohberger's been identified, not back in November of 2022 when they're trying to identify a vehicle.
I don't think that's consistent with the facts, but okay. I think the facts are in the email. It was originally, let's look at this date range. And then he said, well, I'm more comfortable with an expanded, or we need to expand the range through 2015. And that was well before Mr. Kohberger was identified. Now, what BOLA went out, I don't know. I think it may have gone out in two different forms at one point, but the opinion that it could be was before that time, at least as evidenced in the emails.
I agree that in that email, he said expand the search to 2016, but he was more comfortable with a certain year.
Okay, so
I'm trying to explain to the court where I'm coming to my request to the court. I was asked what Agent Imel would say, and I'm repeating it to the very best of my ability. The motion is not about Agent Imel's testimony. I will be able to cross-examine him. He can talk about the videos. He can talk about moments in time where he made certain identifications and why he said what he said in emails. I can talk to him about when the focus for 2014 to 16 changed. What I'm talking about in this motion, what I'm asking the court to exclude, is the prosecutor from standing up and telling the jury that this is the same vehicle all the way through these videos.
that would violate what I said earlier about argument before closing. They may say in opening, the testimony of the FBI specialist you will hear is that this is the vehicle that is seen on the various surveillance cameras. That's different.
I agree. The phrasing the prosecutor has used for a long time in this case is to call the vehicle suspect vehicle 1. And so that's the purpose of the motion. This is my opportunity to ask the court for an order, and that's what I'm doing. Thank you.
Right. So I'm going to write a little something on this issue, but what's that? Did the state not respond? That was rebuttal, wasn't it? Good.
Yes, it was my motion.
Yeah. Sidetrack there. My inclination is certainly the state should not be making conclusions outside of closing statement. I don't think calling the vehicle suspect vehicle one is making a specific conclusion. It's, again, using a term that is used within the investigation, but specifically making an argument that the various vehicles or the various images of vehicles on the various surveillance cameras is the same vehicle. Making that conclusion is an argument, and so that wouldn't be appropriate. I think in opening, for example, you can say that the testimony will be right. As to the agent's ability to make that conclusion, I don't believe that is an ultimate opinion of that is taking the ultimate conclusion from the jury. I think that's right within the province of expertise, and I don't believe, based on the evidence, that it is speculative, such that the agent shouldn't be allowed to offer that testimony. But I will write up further my analysis on that. All right. With that, let's take a lunch break, about 45, 50 minutes, and then we will come back a little shortly before 1, but no later than 1.